Happy Tuesday. Shelly Panzarella here with Hey everyone, happy Tuesday. Shelly Panzarella here with Prosperity Lending. I am so excited to be with you today and excited to be kicking off our sales meeting. So the topic for today for me is open house flyers. It's been about 3 weeks now that we've been able to do these open houses live and in charge. And so I just wanted to share with you our latest open house flyers. And here's page one. It can actually be co-branded, and there's different options that you have for the first page. It's actually a 3-page brochure. Whether you can either print these out or they can be provided to you digitally as well. So for your clients who do not want to actually take the brochure, you can actually get their email information and send this out to them. All you have to do is provide your Prosperity Lending loan officer with the MLS information, and we'll be able to plug in all of the details that come directly from the MLS. So as you can see here, this is one design for our cover page, and you'll see I've got it co-branded here with Bobby Camacho. You would provide your information to the Prosperity Lending loan officer and just make sure that that information is correct on there. And then as we move to page 2, we can get the page 2 is where the fun part begins, where you see all the information as far as the financing information. And this can actually go up to 1 to 3 options as far as financing. So in this specific example, I'm showing conventional financing at 3% down and an FHA financing at 3.5% down. And the middle section here actually shows the cost of waiting. So it'll give a buyer an idea as to what it would look like for them if they happen to wait 6 months, 1 year, 2 years, or 3 years in purchasing this home. One of my favorite things is the buying power, which you'll see here illustrates what it looks like today and what would happen if rates happen to increase. So from rates today up to 4.25, you'll see what that does for a borrower's purchasing power, which in this particular case will actually decrease their purchasing power. And then we've got a great appreciation scenario here, which ultimately shows, based on this specific home and that zip code, what this appreciation calendars look like for the last 6 months, and then as well as a year. So the page 3 is also another example of the information that is provided through in the area. So we can actually change this, whether you want education, you want information about banks, shares what eateries are in here, but this can also be changed for you. So a quick brochure that we can put together for you. I actually put this together for Bobby within about 10 minutes right before our virtual open house. But know that these can be done for you. We can also have these printed out for you in color if you plan to sit at an open house. And again, it is available to you should you decide to actually have this ready for a digital brochure. So that's the information as far as open house flyers. If you have any question about this or anything else regarding lending, please feel free to reach out to one of your Prosperity Lending loan officers. And now I have the wonderful opportunity to introduce one of our favorite brokers, our corporate broker, Ms. Vandana, as she sits with Mr. Dave Sanders as they do their legal update. So to you, Vandana and Dave.
Thanks so much, Shelly, for the mortgage moment. We are super excited here today because because it is election day. So do not forget to vote if you already haven't done so. Today is election day. I've worn my red, white, and blue all over as a reminder to remind everybody that I come in contact with to vote. Have you voted?
I did last week.
Well, thank you. And for those of you who don't know, this is David Sanders. He is legal counsel for Signature Real Estate Group.
Hello.
And we are here to do your legal update today, which I know is so exciting for most. I mean, I love this stuff. So for me, it's amazing.
It's fun.
Yeah.
You know, the idea, one of the things we talked about yesterday was making sure that we had me not just going down the legal rabbit hole and saying it depends over and over and over again, but actually to come up with positive solutions to the extent we can. Right. So I spent most of yesterday
researching the topics I gave you
and coming up with you know, best options for the things we're going to talk about today.
Right. So I think that's the key, right, is that we have all of these issues that come about in our real estate business. But what is, and we can sit here and freak you out about it, but ultimately we need to find solutions. What is it that you can do as a licensee to make sure that you are, one, in compliance and not getting in any trouble with the real estate division, with the state authorities, the federal authorities, because we're going to talk a little bit about that too today.
Yeah.
So just a little intro. David Sanders actually worked for the association for many, many years. I know he doesn't like to talk about it, but he currently has his own law firm now, and he helps with a lot of real estate related type of issues that arise. And the first one that we're going to talk about is something that you actually assisted me with. So believe it or not, I've been doing this since 2003, and I still get into a little bit of trouble here and there, a little bit all the time. And so I'm lucky to have David Sanders as an option to lean on for questions and things like that. And so we figured we just talk about things that have arisen in our office. And the first one that I want to really touch on, because it's not just me, it's happened a couple of times in the last few weeks. Neat, orderly, broom clean condition, right? I mean, that's what it says in the actual contract. In the RPA, it states that the home at the time of possession must be turned over in a neat, orderly, broom clean condition. All right, I have my definition of what that means, but clearly it doesn't matter as long as the buyer and seller understand, right? And I think that's the key. So what's your definition, or is there one?
So what it essentially means is the seller doesn't have an obligation to have the home professionally cleaned, to have the property carpet cleaned, to really do anything aside from getting their stuff out and maybe sweeping the floor. They don't have a legal obligation to clean windows. They don't have a legal obligation to do any of those things. And so for you as a buyer's agent, you really need to be setting expectations to your buyer early in the transaction and explain to them, particularly now with COVID, because there is a genuine concern about that scenario. But the seller doesn't have an obligation to have the property cleaned, doesn't have to. So you need to have the conversation with your buyer and potentially with your seller as well to address that. You know, what do they want? Is there, do they have a health condition? Are they allergic to cats? Are they allergic to dogs? Those are things that you need to know and you need to ask. And most importantly, setting the expectation, because there isn't a legal obligation to really do more than just get your stuff out and, do a once over maybe.
A once over. So there shouldn't be any cat fur in the corner or, right? I mean,
again, the problem you're going to...
Dishes in the dishwasher. Dirty dishes? Could they be clean dishes?
If they're leaving dishes behind, I think you've got other issues than just this now. Mostly, they probably do need to get their stuff out. That's probably one of the issues. But there's no obligation for the seller to go through and repaint walls or fix holes from frames or anything like that as the RPA is drafted. Now, the key there is setting those expectations. If the buyer really wants that, then you need to probably include it in your offer, potentially include it in your request for repairs, maybe, but even then, that's a stretch. So I think that you need to address this, and if you want to have it done, then I think you need to do that. Now, that being said, it's also going to depend on the market, as we've said, because if there are 5 offers and one of them demands
professional cleaning and
repainting the home, professional cleaning, things like that, I don't know how that's going to impact your ability. That's a question for you and your agent.
But also not necessarily doing a bait and switch at the time of the request for repairs and saying, hey, so we knew that these holes were going to be in the wall, and now we're asking for them even though we didn't in the original offer. So communication, I'm hearing, is what's key. Make sure that you explain that to your clients. Obviously, don't act. And here's our attorney saying you can explain to the clients that neat and orderly and broom clean simply means that they will take their stuff out of the home and they will possibly sweep it. That includes carpets, by the way, right? Broom clean. I had someone say, well, how do you broom clean carpets? And I'm like, well, you take a broom and you just, I've done it. I've done it back in the days, pre having a vacuum, pre-adulting, all of those things. It was an option, right?
The key, again, is just to have the communication with the client and making sure that the buyer has expectations that are realistic. If, for example, they have a pet allergy, maybe including that would be something that a seller would be willing to do, but they're not legally obligated in the contract to clean the carpets, get it professionally cleaned, because if that buyer has an unrealistic expectation, you're going to have problems. And so the key here is just explaining that this is what this means. Mm-hmm. It is not, they're not going to hire a professional cleaner to come out. They're not going to spend thousands of dollars repainting the walls. They're not going to do that.
Okay.
And again, in this market, I know I just sold my house. If somebody put an offer like that in, I probably would have said no, because I'm just not going to do that.
I do see in contracts that people ask for professional cleaning to be done at closing, and that I think is legitimate, or you can get a credit of some sort. We do it in contracts for lease agreements, right? When tenants move out, we ask them to professionally clean the property, and it's similar to that, touch up the walls where the holes were, so that it's ready to be, it's essentially rent ready again.
Yeah. The RPA and the lease agreement are very, very different. In that sense.
You don't say.
Yeah. And so if that's something that you want, I think you need to ask for it.
Yeah.
And then the question also then becomes, and I know we've talked about this, is the buyer going to be comfortable with whoever the seller hires to do this?
I'll tell you, if I'm going to buy a house, especially right now, I'm definitely going to hire my own people at the end of, closing to sanitize and clean top to bottom. But I'm slightly freakish like that, so
again, communication is key on this one, because
perfect.
The contract isn't designed to require the seller to do that.
Yeah. Well, and here I have Chris Bishop's voice in my head saying, all right, move on, we get the point. What about, so you've done a walkthrough, and I have had recently a lot of people say, well, the home hasn't been vacant. It's not empty. The buyer refuses to do the walkthrough unless the home is vacant. Now let's talk about that, right? Because in the RPA, again, it says that a walkthrough must be done 2, 3, 4, 5, whatever days you put in there prior to close of escrow. And that's put in there simply because there needs to be some indication to the to the seller if there are repairs that still need to be done, if there was something that was different. The walkthrough is really just to see if the home is in the same condition or better condition than when they first saw it, correct?
Yeah, essentially.
Right.
And make sure that the repairs have been done, all those things.
Well, I'm not an inspector, so I'm not checking on those repairs, and the buyer's not an inspector, they're not checking on those repairs,
exactly.
Right? So even if I've been supplied a copy of all of the receipts and whatnot, Is that sufficient? What do you advise agents to do at that point?
That's a scenario where I see agents getting in trouble a lot, acting like the inspector, pointing things out, verifying. That's really not your role. Again, when you stay in your lane under NRS 645, you're going to be okay. When you go outside of that, you're going to have problems. And that is the key for your entire transaction. You're not a lawyer, you're not a doctor, you're not an accountant, you're not a tax professional. I get that you want to be the go-to resource for your client, but the farther you go, the more problems you're going to get. So back to the walkthrough, the seller has no legal obligation to vacate until close of escrow.
Recording.
They have
like confirmation of recording.
I don't have to vacate my home 2 days early so you can do a walkthrough.
Unless it's in the contract.
Unless it's in the contract.
And they've agreed to it,
They've agreed to it. But if they haven't agreed to it, there's no legal obligation to do that. Nor is there a requirement in the contract that the walkthrough be done when the property is vacant. So this is a scenario where, yes, ideally, you probably would want the seller to be vacated and do the walkthrough. But if they're not, and you haven't negotiated it, what are you going to do?
Wait until the very last minute?
Hold escrow, kick another day? I mean, there's no legal requirement for the seller to vacate it.
So I don't want to dwell on that too much because I know that you did actually a fireside chat with Brandon, I want to say months ago, pre-COVID, PC, but in regards to the walkthrough and whatnot and what should happen if items come about at the walkthrough that weren't originally identified, because the buyer still has to close,
yes.
Otherwise they would be in breach. The seller still has to close, otherwise they'd be in breach, right? So it's a matter of working that crap out afterwards. And so let's talk about that, working that crap out afterwards, right? What does that look like? And how involved can an agent actually be in those discussions? Because I'm finding more and more agents are saying, sure, I'll talk to the buyer for you and see if they'd be willing to give you $200, or sure, I'll talk to the seller and see if they'd be willing, right? How far can we take that discussion without putting our license at risk? Because that is outside the scope of our license.
So it really depends on when we're having that discussion.
Okay.
If you haven't closed, it's still technically part of a real estate transaction. You haven't done this, we want this fixed, we want to resolve it that way. If the transaction's closed and the buyer discovers things that potentially weren't disclosed or repairs that weren't made, that's a very fine line, because sooner or later that's not a real estate transaction anymore, but a potential breach of contract lawsuit between the buyer and the seller for failure to uphold the terms of the RPA. So if it's pre-closing, I think you can negotiate that as a part of the walkthrough. We discovered this, we discovered this. Afterwards, there's gonna be a line. Now, unfortunately, the way the case law is written in Nevada, you guys want, if I do this, I'm okay. If I do this, I'm not. And unfortunately, the way the law is written, it's designed to be intentionally a gray zone. So it's going to be a fact-based scenario. And I know you don't want to hear me say this.
It depends.
But it's going to depend. Because
I told you that wasn't allowed today.
That's the way the law is written.
Okay.
And so I can't change that. But what I would tell you is the prudent thing to do is, if there's things that come up after the close, go talk to your broker.
Okay.
Go talk to your broker. Brokers will call me. We'll figure out how to address this in the right way. So you just have to be careful, because after the transaction closes, your job is essentially done. If there's a dispute, then
it needs to go to mediation, and that needs to be handled with attorneys. You need to consult your clients to go, well, first talk to your broker, and then the broker will get involved and probably say, hey, it's time for you to hire attorneys in regards to this because you agreed to do this, you didn't, whatever, and let's figure this out, right?
If failures to close under SRPD, there's issues that arise there that are statutory. There are lots of different options that they need to figure out. And so to me, the key is having the walkthrough not on the last day, not waiting for the seller to vacate, because then you don't have a whole lot of time to fix this. And then the buyer refuses to close because there's cat hair in the corner. Well,
I mean, you could very easily do something you could very easily say, hey, we're going to ask for, at this point, cleaning, right? And try to negotiate that and maybe get professional cleaning done because there is cat hair in the corner, or fur balls, or whatever you want to call them. Okay, so What about a cancellation, right? So you're saying if after the transaction closes, it could be problematic and it could be you working outside the scope of your license. Well, what about a cancellation? Because technically that's no longer a transaction because somebody's canceled. So at that point, what about the EMD dispute?
That again is where we're going to have some trouble, because sooner or later you're not an attorney, and you're going to have to tell your clients, I can't give you legal advice.
Right.
You need to go talk to an attorney. I'm more than happy to help you in any way with this EMD dispute, give you the file, tell you, paperwork, anything fact specific about the transaction. You're more than happy to talk about and discuss. But getting on the phone with the seller and saying, we demand you give us the money back, is going to be a problem sooner or later, because and you can't represent them at mediation, and so it's difficult in that situation. So it's ideal if you can resolve it between the two. And I'll be honest with you, right now with COVID and everything else, you're going to get a telephonic mediation through the Neighborhood Justice Center, because it's pretty much the only place that's doing it. But the Neighborhood Justice Center is also the bulk of the mediators for the foreclosure mediations and the eviction mediations. So I don't know how much you're going to get. And they cap it at 2 hours. And on a telephone, 2 hours isn't a whole lot of time, because they'll bring you in, they'll do an introduction, as you know, because you're a mediator with the realtors, and then they're going to probably have each side talk, and then they'll caucus. They'll break you off into little groups. Well, if you're on the phone, that means one's got to hang up, you got to talk, and then you got to call back, and that inherently takes more time than a normal process. So I would tell you the best option for everyone is to work it out before mediation, to reach a resolution, because it's going to be expensive, it's going to be time consuming, and mediator isn't an arbitrator, they're not a judge, they're not going to force the parties to resolve. They're very hands off, they let everybody talk. So if you can't get to common ground, then you go into small claims court.
So I want to also just make something really clear. The Neighborhood Justice Center does mediations for public to public, right? My understanding is the association does them too, as long as the contract was predated to a certain, and I don't even know what the date is. So if you're in a brand new contract now, chances are you have to go to the Neighborhood Justice Center for public to public stuff. You can still have mediations done for ethics complaints, for arbitration at the association. That's still possible.
And the arbitration mediation is mandatory. You have to do it. Ethics cases, it's voluntary. It's pretty rare, but you could.
From what I understand is if there's monetary anything involved in the ethics complaint, then they try to go through mediation first. But you're right, it is voluntary. And with arbitration, most people just check the box because they really want to get in front of the panel to, hey, let's just duke this out and make it, right? But let me just go back for a second, because we're talking about working outside the scope of your license. And I've actually had conversations with brokers from other companies who have said that, look, the file's been canceled, right? The buyer and seller have decided that they're no longer, the escrow's done. The escrow has been canceled. At this point, if your agent continues to proceed with trying to work out the EMD dispute, we're filing a complaint against them for working outside the scope of their license under the Code of Ethics, as well as with the Real Estate Division. And so there are brokers out there that are now filing complaints against agents for working outside the scope of their license, for negotiating disputes on earnest deposits, or disputes that are dated after the transaction's been closed. So be very careful when you do that. Make sure you talk to your broker. I think that's the main key, right? Talk to your broker. We'll make sure that we get the right advice to you on consulting an attorney. Because here's the problem, is that a lot of buyers and sellers believe that just because we help them through the transaction, it is now also part of our job to take it to the next step, to help them figure out this dispute, whatever it may be, because it was related to the transaction. They don't get that it's not. It's actually illegal, you need a license to do that. And I'm sure the Bar Association will have a problem with that.
The definition of practicing law in the state of Nevada is advising anyone on any issue that impacts any legal right.
Well, hallelujah, there we go. There's the definition.
And so it's designed to be a very fact-centric scenario.
Yeah.
If you're still under contract and there's a dispute and people technically haven't canceled, they haven't signed all the paperwork, there's that. I think you can do that. If 3 months down the road they find things in the property that are problematic and weren't disclosed in the SRPD, I don't think you can do that.
Then they have to start suing.
So the really in this scenario is you need to talk to your broker, because there isn't a bright shiny line, and every situation is going to be different. So if you think you're going to have this dispute, even if it's still under contract and you're still trying to save it, I think you need to bring your broker in, because you need to have that conversation before things get out of control.
Got it. All right, so we have like 6 more things to talk about. We've
Perfect.
gotten through 2 for our real topics. So let's talk about turning in your files with the broker, right? So I know that we've talked about this as a brokerage quite often, and I know that there's some ramifications of not turning in your files. Obviously, NRS and NAC say that you have to turn them in within 5 calendar days, right? Okay, so what happens? Talk about that.
Well, so the statute is very clear, and for example, if you don't turn in a complete file and the division contacts signature for the file and there's documents missing, the division could potentially hit you with another claim that you're intentionally withholding documents and impeding the investigation. So you're already potentially looking at, if for example you don't include the duties owed, for example, you turn the file in but you don't turn in the duties owed, or something along those lines. That in itself is another problem with the division. So turning your file in on time and complete is really the only way that you're going to protect yourself when they pull it, because you're going to forget, you're going to get busy, and it's going to get lost in the shuffle. So you really need to. It's the only really way to protect you when the division says, we want to look at this.
Right. And if you don't have a complete file with the office, quite honestly, you shouldn't be doing real estate, right? You shouldn't be working with a buyer. You shouldn't be working with a seller. We need to have those files in office, I think. Okay. So I'm not going to go over it. I know we're going to probably talk about it during our broker potpourri next week. So let's talk about clear cooperation. This has come up quite a bit because it's brand new for this year, right? We have a new listing agreement that showed up in April that talked about clear cooperation, and sections 18 and 21 have to be marked accordingly, and blah, 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 blah. But agents are working or trying to work around the system to make it where they can actually advertise properties without having to talk about that. I know I didn't finish my sentence, but okay. You know where I'm going.
According to the NAR, this is not a policy that you cannot opt out of. Brokerages can't opt out of it. Clients can't opt out of it. If the simple rule is, for better or for worse, you got to put your listing in the MLS within 1 business day. Now it's business day, so that excludes Saturdays, Sundays, and state and federal holidays. So if, for example, you entered into a listing agreement last Thursday.
Right, then you had Nevada Day, you had Saturday, Sunday, and now Monday would
have been
right.
the day you had to address that. So it is not something you can opt out of. And the fines are pretty hefty.
What are they?
About $1,000 for the first shot, $5,000 for the second and third.
Holy.
It's a lot.
Cheese and rice. So what about the fact that agents, so because it says 1 business day after public marketing, right? So what if I don't publicly market it?
Well,
you weren't prepared for that. Sorry.
The problem is the way they've defined the policy is, what do you mean by public marketing? The only place that you can put it would be some side of like internal website or thing with signature, potentially.
Okay.
Everything else, anything that anyone in the public can see, ticks it. So your Instagram account, your TikTok, whatever you're doing,
Instagram, Facebook, TikTok, LinkedIn.
If you technically, go and knock on someone's door and say, hey, I've got the house next door for sale. It's any advertising, marketing, any kind of marketing at all to the public ticks that 1 day. The only exclusion is if you're going to keep it inside the office internally.
Yeah.
But you still got to turn the paperwork in. So.
I mean, if you're knocking on doors and telling neighbors that you got a house listed, you better be careful that's not a realtor, because they'll be the first ones to turn you in.
And here's the thing. all you got to do is take a screenshot.
Yeah.
And we see it all the time. I see it on social media all of the time. And all it takes is one person to take a screenshot. And this is not like an ethics complaint where you have to file a complaint. This is an MLS violation, which just means they just have to send it into the MLS, and the MLS takes it and runs with it. So it's not like an ethics complaint in that sense.
So you mentioned you could put it potentially in so we're going to jump ahead to something that we were going to talk about later, but we'll talk about it now. You said you could potentially put it in, a private page like we have Agents of Signature. And we see that quite often where, agents will say, hey, this listing's coming soon in the next week, whatever, but it's not actually in the MLS yet. Now, my understanding is that almost looks like its own MLS, right? And so Janet had mentioned something yesterday about the FBI going into, and I think you said it wasn't the FBI, but
it could potentially be. I wasn't able to find any paperwork on this anywhere. So
yeah.
There are both criminal and civil penalties for antitrust violations.
Okay.
So it just depends. There are also the Department of Justice handles them on one end, and then also the SEC handles them as well.
Right.
So there's multiple federal agencies that would be involved. It's potential that the FBI could be involved if they're looking at criminal actions. So the problem that I think you get, it's not necessarily Signature having their own Facebook page, because that's the brokerage, you're internal. You can talk about stuff. You can talk
without
about
breaking
commissions. You can talk about those kinds of things
internally within our company. Yeah.
The problem would become is if Signature and another or a non-broker related closed Facebook page started talking about commissions and started talking about price fixing and started talking about we need to boycott, insert competitor's name here, those kinds of things. So it's okay for your internal brokerage to have the conversation about this is the amount of commission we at Signature have. That's okay. You can do that internally. But if for example, a committee of the association or a online Facebook group about real estate, because I know there's lots of them out there, that group start talking about it, then you got potential problems. And then the problem you also have with antitrust laws is they do not require intent. If you're a member of that group and they start talking about commission, your membership is arguably enough to get you in trouble. So you would need to affirmatively get out of that group and make a comment.
Hey, not okay. Don't want to be a part of this discussion. Yeah.
So I'd be very careful with that. And closed Facebook pages are not immune to subpoenas, and law enforcement, they use them all the time. There's been antitrust enforcement with dentists sending price fixtures on dental dentures in Florida through a Facebook page. There's been, that's not a protection. A private Facebook or a closed Facebook group is not designed to protect you from civil or criminal possibilities.
Okay. Well, what about private MLSs?
Well, that's
through a private Facebook page.
That's I think that's a potential problem. I would tell you to not do that. Is the answer.
Thanks, David.
Because if there is private groups that setting aside the antitrust rules, because of clear cooperation, you have to put it in the MLS. A closed Facebook group outside of your brokerage is advertising, I think, the way they defined it. Then you also have the scenario of, are you boycotting? Are you saying, okay, well, we'll only list it to these people we like, but these other people we won't do that. You've got problems with the Code of Ethics, you've got problems with NRS 645, and you have problems with antitrust law in that scenario. The best answer is put it in the MLS within one business day.
I thought you were going to say it depends, and I was about to throw my coffee at you.
That's really the only option, unless NAR decides to change their rules, which I don't think they will.
I mean, we do have a meeting coming up in the next week, but chances of that happening are slim to none, right?
They fought this for a very long time to get the clear cooperation policy was actually passed in October of 2019, but didn't put into place for about 6 months so that you could get the word out. and whether or not the word was given out before the listing agreement changed is a story for a different day. But it was intentionally delayed for 5 or 6 months so that they could communicate this, so that NAR and the local MLSs could communicate this, that it's not an opt-in. You can't opt. The only way you could really get out of this policy is if the seller says, I don't want you to advertise my home on the internet, and they opt out of that. Then
you're looking at office exclusive listing.
Well, then you're looking at them opting out of the display on the internet, which I don't know how many homeowners are actually saying, don't put my home on the internet.
The ones who don't really want it to sell.
Yeah, so that's the only scenario where I think you could potentially get around this. But unfortunately, and the fines are very severe. The first time I said is $1,000.
Yeah.
Second is $5,000. Third is you have to go down to the MLS committee and explain yourself, and a fine.
So we don't have to talk about this time, but you did open the door to it on the opt-out things. I can't tell you how many times people are like, well, why would anybody opt out of that? And the commentary, the internet, there used to be 4 of them, and now there's only 2 left.
So what this was is in the early 2000s, the federal government came and looked at the MLS for antitrust violations. The Department of Justice came through and actively investigated NAR and the MLS, arguing that it was a violation of antitrust law, and that so as a part of the negotiation to have that lawsuit go away, NAR entered into an order with the Department of Justice where they would agree every quarter to do certain things to report back to the Department of Justice in the consent decree. And a part of that consent decree was that required language.
Wait, what are you saying? It's
a consent decree.
Consent decree.
Yes. So
okay.
That is a thing where
it just sounded like one big word, but it's 2.
Sorry.
Got it. It's okay.
I get so excited talking about consent decrees. So what that is where the parties go before a judge and say, Judge, we've agreed to do this. In exchange, they're not going to continue their investigation. They determined that the MLSs are not a monopoly, and they're actually beneficial for the homeowner. This might sound familiar because there's a big lawsuit about this again.
Yeah.
So that consent decree expired in 2018. And NAR decided to continue requiring that language even though the consent decree's gone away. So part of the reason that's the reason why it's there, because they agreed to it with the Department of Justice. It cannot be removed from the listing agreement. It is also slightly antiquated because the consent decree was so early on in the internet that it has some quirky language in there, but that's why it's there. And so there's not a requirement under MLS rules and regs to use the association's listing agreement. You could potentially.
You do have to get them approved, though.
But you do have to get it approved, and the reason why is that language can't be removed because of the consent decree. Now, there was a lot of discussion what NAR was going to do when the consent decree expired, if they were going to continue to acquire it. They did. I think that's a good idea, particularly considering the other litigation that's out there.
Which is?
The class action lawsuit against NAR, alleging that, and several MLSs alleging that requiring a compensation amount in the MLS is a violation of.
To be paid to the buyer's agent.
To be paid by that offer is a monopoly in violation of antitrust.
So that's probably its own meeting all by itself. So I don't even want to touch that until the next time you're
and
you're
unfortunately,
here.
that's a very, very long lawsuit. The motion to dismiss was denied. You probably saw that on social media, thinking it's the end of the universe. A motion to dismiss is
the sky is falling.
Is the standard for review of a motion to dismiss for those of you who are on grievance committee is very similar to the grievance committee review. In the light most favorable to the plaintiff, is there a possible lawsuit here? That's it. That's a very low bar to pass.
Yeah.
Just like grievance cases, most of the time they're approved and sent on. So.
Yeah, because you only get the complainant's information, you don't get anything from the respondent. Okay, so let's save that and put a pin in it for the next time you're here. And let's talk about federal fair housing. Okay.
I'm a fan of it.
Yeah. So federal fair housing, specifically related to what their role is in love letters. And then also in marketing photos, right? Because I am seeing a lot now that people are, in fact, I had a broker call me from another office asking me for advice on his marketing photos. And he was like, hey, so what do you think about these? I know that you teach a class on advertising. What do you think about these? And I said, well, they look the same, right? I mean, you have what it looks to me to be a single female white that is in both your photos. They look different, but they're both the same, right? In that essence. So, I mean, commercials get away with it all the time, right?
Well, the problem is that most commercials don't have to comply with fair housing.
Okay.
But you do.
True.
Yeah. The answer is, I wouldn't use models. Because
like ever?
The recommendations for models, you have to comply with fair housing. And so if you so the best recommendation is, if you're going to use models, you better make sure that you've got old models, you've got younger people, you've got kids with children, without, male, female, a variety of
ethnicities,
of protected classes. Because
all in the same?
Potentially, yes. I mean, if, for example, hypothetically, you create an advertisement that appears to be appealing to only people with children, that's a violation of fair housing.
Okay.
Potentially. So the only way that you can't run afoul of that is to not use human models at all. Then there's none of that. But
so, I mean, I've mentioned this a couple of times in our meetings. I saw, and probably the only one that I can, there's two actually that I can cite where there hasn't been human models. Like one, we had obviously Andrew was the Sasquatch in his photos. So he used the Sasquatch, which is not a human model, right? It is a animal, and they're not a protected class. So that would work,
I believe
right?
So.
And then zombies, like walking through a house with zombies. And that was the other one that I saw, and it was an ad that came out from California, but it was a video. And so that seemed to be okay and within federal fair housing. But I know that agents do it all the time, right? And the guy who called me this weekend was just like, ever since I put models on my pictures for marketing, obviously you can't put them in the MLS, but modeling on his website, the properties, he said that he's gotten higher clicks. And I said, well, yeah, because your models are hot. But at the same time, they could be a violation of federal fair housing. So
the only thing I think that you could get, you could potentially do models, is if it's an age-restricted community and you're very clear on, you must be X age to
live here. Yeah.
That is the only one that you can do under fair housing. The problem becomes is you need to show a diversity. You can't, we know from print, we know from case law that using phrases like great bachelor pad, walking distance to schools can potentially get you in trouble.
Or insinuating those types of items, right? Insinuating with a male model, in the home that it's a bachelor pad, right?
And so that's where your problem becomes, is there isn't a clear, the answer, and I looked at associations all over the country, I looked at fair housing groups, and they're all saying, if you use models, you need to be diverse and you need to do that. Now, you can do things like, second story walk up, that's okay, that's not a violation of the ADA or anything like that. But if you're gonna use models, you really need to make sure that you are not unintentionally violating fair housing, not implying that, the only people who can purchase this home are a specific group. So I would be the easiest way to do this is to not put models in your photos. Now, I know that may not be a marketing thing that you want to hear, but the easiest way to not violate fair housing is just not to use models.
All you need is one person to turn you in, right? Screenshot, bam, send it over.
Maybe
more.
You have the situation where yes, you could potentially, it's part of the realtor code, so they can file an ethics complaint against you.
Okay.
If you have not had the pleasant experience of being investigated by HUD for a fair housing violation, it's a long process. It's very drawn out, and it's not exactly easy.
Okay. Fun stuff.
So there's your answer. Don't do it.
Well, hey. So we're solution-based here, and the solution to that is don't do it unless it's a zombie or a Sasquatch.
Well.
Hey, Andrew, are you up for hire?
It's not, I would tell you, if you're going to do it, you could just need to look at, what the protected classes are and make sure that you're not violating that.
Yeah. So let's talk about love letters really quickly, because
Okay.
that was my first part of the question. You've avoided that and I didn't forget. So love letters. I'm a buyer's agent. I've got a buyer who really loves this home and wants to write a letter, because that's what they do in other states, right? And we've seen them more often here. But I know California does them a lot. When my brother and his wife bought a house, they wrote a love letter. And it was very like, hey, we're starting our family. This would be a great place for our daughter, blah, 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 right? So as a buyer's agent, what am I advising my clients, or what am I not advising my clients to do? And on the listing side, what does that look like? Because we get them all the time, and we do.
The seller cannot. Protected classes fair housing applies to this scenario. You could, for example, if a seller has got surveillance in their home and they see that a potential seller is of a protected class and say, I don't want to sell to them because I saw them and they're insert protected class here. That's a violation of fair housing, so you need to be aware of that. The seller, you can't make a decision based on any one of those particular classes. And where you're going to run into problems is the buyer's going to say, they rejected my offer because in my letter we wrote that we were a family and we're a protected class. I would be very careful about that. Now, buyer saying that, describing their family and their those kinds of things, I don't think that's a per se violation of fair housing. I think it's really the seller's choice in that situation to be more careful about. I certainly, as the agent, wouldn't be drafting those letters for them. I certainly wouldn't do that. And in advising them that this is the situation. And what I'll do is after we talk today, I'll go and come together with some tips on how a buyer can express how they feel about the home and not run into problems. And more importantly, the seller. I think the seller is the one that has the bigger issue there. Yeah. If they're saying no because
everybody puts pictures on their love letters too.
Over the age of 65 or whatever. I think the conversation with the seller, if you're getting that, is look, if it's there's this thing called fair housing, here are the protected classes, and make sure that you get the ones for both federal and Nevada, because we have a broader definition under state law than the feds do. So you want to make sure that they're not making a decision based on that. Right. And the problem I see is if the offer with the letter is rejected, it would be very easy for a buyer to say,
it's because
of this.
Right.
And so if you are, I would make sure that you explain to the seller they can't make that decision based on that.
So maybe that's a good conversation to have at the listing appointment when you're going over the listing agreement and saying, because there is a section about federal fair housing.
Yes.
And so you can say, we may get an offer that has a love letter attached to it, and that simply means that the buyers are going to be presenting something. You must comply with this section of the listing agreement. And that's sort of a good opportunity to remind them at that point, yes. Right?
And also to talk about if they have internal security or surveillance cameras in their home. Just so that it's clear on this one with surveillance, because it always comes up. Nevada is a one-party authorization state, meaning that if I'm the seller and you're coming into my home, I can record you, and I don't have to tell you you're on camera.
Right.
And I can use it for whatever reasons I need to. I don't have to disclose that.
So don't talk crap in the house.
Don't.
Or even outside the house. I can't tell you how many times I've had sellers send me the Ring data or the video from the Ring. They're like, they love this house. They're totally putting in an offer. They're going to do it for more or for less than what they are able to do it. So like you already know, you've given away your negotiating powers. So don't talk about
you don't talk. And frankly, particularly now with COVID, I think you need to explain not only the COVID requirements for being in the home, but also that you have to assume we're being surveilled. So make sure that because I know I would not be happy if they weren't wearing masks, they weren't doing those requirements when they came into my home.
I agree.
And so,
especially when I asked for that to be done or to wear booties or whatnot, right?
Whatever. So I'd be careful with that. But so there's no requirement for the seller to disclose. People always think there is. They don't have to.
Yeah. Well, I mean, so let's talk about the buyer-broker agreement really quickly, because I think this ties in a little bit. Is in the buyer-broker agreement, there's actually no place to have a discussion about surveillance, right? And if you're not, and so this is that broker moment where I say, I think it's a good idea all the time to do a buyer consult, right? To sit down and have them sign the duties owed and the buyer broker agreement, and therefore you set the expectations. This is what it's going to be like. This is why why it's important for you to sign this. I mean, quite honestly, Article 9 says that you have to have all agreements in writing, right? And so if you're agreeing to work with a buyer and buyer's agreeing to work with you, that should be in writing, and that should be under the buyer broker agreement. And so you can look at the code of ethics as a way to help you get this buyer broker agreement signed if you're having struggles with that.
The buyer broker agreement is designed to protect you as an agent.
Yeah.
For example, there's language in there about referrals, so you don't run afoul of RESPA. There's language that's designed to protect you. We can't do that. We can't do, there's a damage cap in the buyer brokerage agreement that says, look, if the buyer decides to sue you, all they're ever going to get is your commission rather than whatever the damages are.
Which, by the way, was one of the most brilliant things that we did as an association. And I remember this was your last year on forms committee. I sat on it. I think Brandon was the vice chair, and you were like, I think this damages cap is the thing that we need to do. And there was not a single person in the room that disagreed with you.
You know, I'll be honest with you. If the damage cap language is twofold. One, it does protect you, and then two, it also tells you if a buyer says, I'll agree to the agreement, but I'm not gonna do the damage cap, then you know exactly what you're
up against,
what you're getting into.
A litigious person, and guess what?
But
refer them out.
There's no
somebody
way
you don't like.
to contractually do. You have to do that in a writing. You have to do it in a contract. So all of that protection can't be done verbally. You can't do it. You don't technically have an agreement. You have statutory obligations, duties owed, things like that, but there's no contract language. Make sure that you sign the duties owed. The buyer broker agreement at the very beginning of the transaction. There was an ethics case. I know I told you about this one, but it boggles my mind. There was an ethics case involving a very wealthy individual purchasing a 6-7 figure home, but it was from a part of the world where they don't have exclusive real estate relationships. It's just not the norm. So when he was asked if he signed a buyer brokerage agreement, he said, yeah, I signed 6 of them. He had 6 agents out looking, including 2 that bid on the same home. So he was literally putting in offers with 2 agents on the same home. And so the key came down to on this, who was procuring costs was not if there was a buyer brokerage agreement, because there was multiple buyer brokerage agreements. The question came down to when was it signed. First one signed it when they first met with the buyer. The second signed it when they submitted the offer, and that was about a 6-week gap, and that was the decision for the panel.
So the person who signed it at the beginning is the one who
ended up being procuring costs, even though the person who had the later buyer brokerage agreement had been working with the client longer.
Got it.
So if you're going to use it at the very beginning.
Okay, so that still doesn't answer my question about when's a good time in the buyer broker agreement to talk about we could be recorded.
We have that general disclosure.
Because I've never actually talked about it, to be honest with you, and it just
have that there's the form that the association came out.
I love that form. That's the one that we did.
Yeah,
it's the buyer's notice of disclosure. Sorry, I don't mean to interrupt you.
The surveillance language is there, but I think that you can always talk about it and just tell them that they need to assume that they're under surveillance. And 3-4 years ago, I think people would have really had a hard time with that. Everyone has a Ring camera now. It's not that big of a deal. It's not as big. It's not as a surprise anymore. Mm-hmm. Because the Ring cameras and those types of systems have become so prevalent that you have to assume that you're under
surveillance at all times.
Audio and video. Yeah. So
yeah.
The only place that you have the case law says that you have to have an expectation of privacy. So that's why when you could go to the gym and you would go into the locker room, there would be a gigantic sign that says you can't use your phone in here, you can't use your camera in here, because there is an expectation of privacy in a restroom, a locker room, those kinds of places. So
got it.
You don't have an expectation of privacy walking through another person's home.
Well, and here's the thing, I guess as an agent, it's really important not to be involved in those types of conversations, because even if there is surveillance in the house, now even if this particular buyer isn't the one that's moving forward, that client, that seller already knows that you talk crap, right? And so when you come back with another buyer who actually wants to buy the house, they're gonna look at that differently, right? I mean, you just have to assume that you're going to be under surveillance all the time.
The days are gone where you prove your value as a buyer's agent by pointing out the flaws in the home while you're inside. You'll need to do that outside. And particularly also with COVID, I don't know about you, but I want to go in, walk, and get out and not be in there, because who knows?
Just be done. Yeah.
Yeah, so don't talk anything about transaction,
Negotiations, your strategy,
sellers,
anything.
Sellers, items inside the home, all of those things. So.
Yeah. Well, we're about to come to an end. Was there any last minute thoughts, anything that you were like burning desire to tell the agents in our office about what they should and shouldn't be doing, things that you've seen?
If you have questions, you need to ask your broker. If you're not sure what to do, ask your broker.
That's it. That's all you got. That's it. All right.
That's the best advice. It answers all the things we talked about.
So ultimately, if you have any issues that arise, we want to know about it before. And I think that's the key, is that we can help you sort of navigate through the process versus having to fix it later, because fixing it later sometimes takes a lot longer. So, get us involved early enough, I think, is the key. Yep. And with that, I mean, I'm done, you're done, and I haven't gotten any questions. I got a text from Brandon, and I thought it was important, but it was a voicemail or something. Brandon, I'm doing a meeting. But anyways, so we are done. Do not forget to go out and vote today. It is election day. Whoever you vote for, it doesn't matter as long as you vote. Have your voice heard. Remember, elections have consequences no matter what, even at the association and beyond.
The part of your voting today that will have the biggest impact on you and your real estate business is the judges that we elect in the state of Nevada.
Yeah.
They're going to impact evictions, contracts, the whole nine. That is very important and will have a direct impact on your business.
So, I mean, we have had questions about that on our Facebook page, and a lot of people, and we as an association do not put out recommendations. Poor PAC, never PAC, we never put out recommendations for judges. And so I guess if you're looking for that information, I did post it a couple of weeks ago. And
they do on Justice Court.
Yeah.
Because Justice Court has exclusive eviction jurisdiction. They don't on the district and the Supreme Court, because there's just not as much impact day to day on real estate.
Yeah, so reach out. We'll be able to help you as brokers on which direction to go for judges. But whatever you do, please vote. And that's it. That's a wrap, guys. Thanks.